So welcome everyone to the fourth webinar run by the Royal Australasian College of Surgeons and the Victorian Regional Committee for the Preparation for Practice series. Tonight I'd like to welcome my co-moderator, Mr. Patrick Lowe, and to kick off the evening, we are going to discuss a few important topics relating to private practice. Working with TAC and WorkCover, legal contracts, how to organise for those contracts to be drawn out correctly, bullying and harassment in the workplace. And these topics are going to be discussed by our legal advisors, Tim Jackson from Zapparas Lawyers and Emma Byrne from Baker and McKenzie Lawyers, who are our keynote speakers for this evening. Firstly, I'd like to acknowledge the traditional owners of the country throughout Australia and recognise their continuing connection to land, waters and community, and we pay our respects to them, their cultures and to their elders, both past and present. On behalf of the Victorian Regional Committee and RACS, and in particular Catherine and Virginia, who have done a lot of behind the scenes work for the webinar series, I'd like to just inform you of a couple of housekeeping rules for today's webinar. Firstly, we want you to type and send in all your questions relating to these topics so that we can actually invite our speakers to answer them at the end of the webinar. We will keep the questions to the end. And there is also a survey which we'd love you to complete at the end of the webinar to give us some feedback on what you thought and how we can make improvements for the future. So without further ado, I would like to invite our first speaker, Tim Jackson from Zapparas Lawyers. Tim, take it away.
Perfect. Thank you very much. And I'll just get my PowerPoint up, so bear with me as I do that. Hopefully that's now on everyone's screen, and I'll just put it into this mode. Just want to check that everyone can see that and that's working fine. Beautiful. Okay. Well, thank you very much, and thank you for the opportunity to speak to you all tonight. As mentioned, my name is Tim Jackson, and I'm one of the senior associates here at Zapparas Lawyers. I manage and run an office for the Zapparas family. Yianni Zapparas, who was supposed to be here tonight, sends his apologies. Unfortunately, with COVID and where he is at the moment and schooling, he's got to get his kids up and ready for remote learning tomorrow, as I understand. So he passes on his regards for being unable to be here tonight. For those that don't know about Zapparas Lawyers, we're a family-run and owned firm. Started by Peter Zapparas almost 40 years ago and his wife Leah, and now run by them together with their three children, Yianni, Zoe and Paul, and they all manage different departments at our firm. We have a number of offices across Victoria and a couple in Queensland, so there's generally an office close to where you practice. Oakley is our main office, but we've got offices all across Victoria, and as I said, two in Queensland, but also one in Bendigo as well, with more plans to come online later this year, or depending on COVID, maybe next year. Tonight's topic is really about medical report writing, what to include in your medical reports, why we ask some of those pesky questions. I know as a solicitor, I often ask some very annoying questions, and I understand as surgeons that can be annoying at times. So I want to sort of give you a peek behind the curtain as to why we're actually asking that question, and there is a bit of method to our madness, and also sort of talk you through some tips and tricks about report writing as well. And as Marilyn said, you can send any questions to her that you might have, and at the end I'll be here at the end to answer any questions you might have as well. So basically, really getting started, when are you going to be asked to write reports? And on the screen at the moment, this is sort of a patient's journey through particularly WorkCover, but also through TAC. They lodge a claim. The claim is either accepted or rejected. If it's accepted, they have entitlements to medical services, surgeries, consultations, injections, They also get some income benefit, and there's some potential compensation claims as well that are available to them. And so when are reports required? Well, generally every point across a client's case, a report can be required, and it can not just be about compensation. A lot of the time I know I'm requesting reports, particularly about treatment, when insurers are not paying for treatment and trying to get that treatment covered for your patient, and so they can get back to work if they can. And I've always thought this, that a good report is always going to keep you out of the courtroom. If you write a good report and spend a bit of time writing that report, a lot of the time you're going to be able to avoid having to come into the courtroom. So some basic principles about report writing. Short and sharp. A couple of pages is fine, maybe 3. Past that point, I think it can often be too much information. Us as lawyers will often get your clinical notes. Your notes will already be available to us. So the report's a real quick summary of those notes in your interactions with your patient. So what do we put in a report? This is sort of the outline of what to put in a report, but I'm going to kind of work you through tonight each one of them and why we think you should put them in. And, some are quite obvious and others not so obvious. Of course, most obvious is history, the history that the patient gives you when you first meet them, the history that you get from that referring doctor to you. And history is really important. And I often use a case of ours to illustrate that. We once had a client who simply lifted a toolbox at work. And when he lifted that toolbox, his back absolutely went and needed a fusion. The fusion failed, and he was left in an awful state. Along the while, that case was rejected by the insurer. We had a battle to get it accepted, and it ended up having to go to court to battle to get any money for this client. And the key in this case was all about the history. What the client hadn't told anyone, and through no fault of the doctors, of course, but hadn't told anyone what he was actually doing the whole 2 or 3 weeks before his back actually went. And he was on a work site lifting these heavy ducts. These heavy ducts were weighing in excess of 50, 60, 70 kilos. And so the action of him lifting the toolbox, really his back was about to go at any point. And without him having given that history, it was really hard to succeed in that case. But also on the flip side, I'd encourage you to take a little bit of time to really get that history behind what happened in the lead up to it. So you see there the nature of work, what's their occupation? What tasks are they doing? Is it repetitive? What sort of work is it? Is it heavy, light? Is it awkward? When did it occur? And more so about the symptoms as well. When did the symptoms start? Did they gradually start, or was it sort of one frank day? And that history right at the start is really helpful for us as lawyers to get cases accepted. Because if we can point to the insurer and say, well, the story about how their injury happened was exactly what they told the doctors, is exactly what they're telling you, that really gives a client a good chance to get their claim accepted, and gives them a real good chance to, get that surgery accepted and that treatment accepted. Pre-existing injuries, always really important to talk about pre-existing injuries in reports. Often I find when I'm talking to doctors and surgeons, they say to me, well, Tim, I didn't put anything about the pre-existing because I didn't really think it was relevant. It's clear that he recovered from that low back complaint 5 years ago. He was back working full time, so I didn't include it in my report. But what the insurers don't know is what you've thought about when you've written that report. So my always advice is, even if, for example, they had a lower back complaint 5 years ago and they'd recovered and they were back at work full time, if you say that in 1 or 2 lines of your report, that's going to cover off that pre-existing argument, and that's going to deal with it. Although you've rightly thought about it, you rightly didn't think it was relevant, pop it in the report, and because that's absolutely really helpful for patients to sort of, instead of insurers trying to argue it's all pre-existing and work's not related and that's why they're not funding your surgery, putting in those sort of questions that we asked there did they recover? Did it affect their work capacity? Is there a difference in radiology now? They're really important things to have a look at. The next, obviously, is diagnosis. You guys are the experts in this, not me, and you guys are the right people to give the diagnosis. But I would say this, under the law, under TAC, under WorkCover, an aggravation of a pre-existing injury is still covered by WorkCover and TAC. So you might have a couple of bulge discs that, weren't symptomatic at all, had just been sitting there, but because of the accident or the work injury, they've now become, symptomatic. Although they were already there, that is still classified as an injury. It's still covered under WorkCover and TAC. Same with acceleration. They might have had a bad knee in the past and there was a bit of arthritis, but they've injured their knee at work and the arthritis has really come on much quicker than ever anticipated. The acceleration of that can still be classed as an injury under WorkCover and TAC. You'll see there's a high court case authority that we've just put there that sort of points that out to us as lawyers. Obviously, when you're doing your diagnosis, consider, is there abnormal illness behaviour? But when you're doing that, look at their cultural, their anxiety. Someone who's an illiterate refugee might, react entirely differently to someone that can speak English and understands the system and understands what they're doing. So just take that into consideration when you're doing your reports. Other diagnosis, is it chronic pain syndrome, but is there some organic basis to that? Time and time again, we see lots of court cases all about chronic pain, but they are accepted. They can be won, but if we can link some organic basis to them, they're much easier to succeed. Surveillance. I don't find often that surgeons get a lot of surveillance. I find more so surveillance is sent to GPs or independent medical examiners, but from time to time, you as a surgeon might have written a report about a client and then you'll be sent a follow-up report from the lawyers saying, oh, have a look at this surveillance. Does this surveillance change your opinion? And I think surveillance should be looked at in how it is filmed, and that is in isolation. They've captured a moment in time of this client's life. They haven't captured what they've been doing for 24 hours a day. They've captured a moment. And so I think it's really important to have a critical think about that surveillance when you've shown it. Often we get surveillance reports as lawyers that say they've done 30 hours of footage and they've produced 2 minutes. And so look at the fact that it's done in isolation and consider the treatment and the medication they're on. They might have seen one of your colleagues the day before and had an injection into their spine, and that's why they're walking around freely on surveillance. So I often say, if you are asked to look at surveillance, the best approach is to get the patient in and ask the patient what they were doing in the lead up or around that surveillance and getting a bit of history yourself about it, because that will give you a better stead in responding to that. But also you're at less risk, in my view, of being called to court and saying, well, you saw that surveillance and you didn't change your mind. And, the next question from the other side is going to be, why didn't you change your mind? But if you can say, well, I didn't change my mind because I saw the patient came in, I confirmed, one, it was him in the film. Often we see it's not them in the film. And two, he told me that yes, he pushed his garbage bin out to the front door, but then he went inside and had to lay down for 2 hours. They don't get the full history in that surveillance. And so I think it's important when you are asked to comment on surveillance to get that full history. We see from a lot of time now that they're using Waddel signs. They're saying, well, he's using the Waddel signs, they're faking it, they're not making it, they're making it up. But Waddel himself has actually come out and said the 8 clinical signs that he put together are actually being misused. So I just warned a bit of caution about that, and the courts are picking up on that as well now. some basic principles about, linking it for WorkCover or TAC. It's got to be a material contribution. That is, that the injury has to have some link to the incident itself. There's a quite lengthy legal description there, and I'm not going to take you through it all. But really, it means, it can't be fanciful. It has to have some link to work. It doesn't have to be the only link. And going back before where I said somebody that might have a bad back and or pre-existing back injury that's aggravated at work or accelerated at work, this is the exact scenario that, work has still contributed to that. Is it the entire cause? No, probably not. But does it need to be the entire cause of their injury? No, it doesn't. There needs to be a link to it. And that sort of just sums up, work does not need to be the sole or dominant cause of that injury. Causation under the WorkCover Act, and this is particularly on WorkCover now, there are a number of injuries and course of employment type injuries where work must be what we call a significant contributing factor. If you are ever asked in your reports, was work a significant contributing factor? I hope, as is my practice, to actually send you the list that you see below on your screen of the factors you actually should consider when looking at whether work is a significant contributing factor. They're the lists out of the legislation. If you get a question like that from any lawyer about it whatsoever, I would keep this list handy and refer to it when you're doing your report. Occupational diseases in Victoria, especially for WorkCover, as we've seen, silicosis, there's a big rise, chemical cancers, exposure to asbestos, all these types of injuries are covered under WorkCover. And often with these types of conditions, if you can prove that they were in an environment at work that had this, that's all you need to do. It's then a rebuttal presumption that forces the insurer to actually argue that it's not work-related rather than us having to argue that it is work-related. And we know with these types of conditions, they can take some time to come through. Silicosis has been in the media a fair bit recently. And in fact, WorkCover have now set up a program where you can get a free scan for silicosis. You can get to a free specialist for silicosis as well. So if you or any of your colleagues suspect that, there is a program through WorkSafe now that provides that service before a claim is even accepted for free for injured workers. You are often asked about clients' work capacity. Can they work? When you're looking at that, take into account, your examination findings, what their, tolerances, intolerances are, what the medication does on them. Can they go back to their pre-existing work? But give it a bit of a holistic view. So age, education, their experience, where they work, those sorts of things. Have a we call it a degree of realism is the technical term with the law, but really we're saying when you're asked the question about can they work, it's not just can they work based on just the clinical finding. Have a look at their age, their education, how far they have to travel for work, for example. They might technically be able to go to work, but can they even get there on the medication? Can they even drive on the medication that's being prescribed? So giving that holistic view. And this is the case, and it's a recent case in Victoria, Richter and Driscoll, it's called, in the Supreme Court, that essentially said that. It said that when you look at a client about whether they can work or not, you've got to have a holistic assessment of them. And as I said, degree of realism, and I use that word because that comes out of a magistrate's court case in Victoria. That's pretty set law at the moment. It's been set for about 8 years now. We often, as I said at the start of this, I know we often ask you pesky questions, and one of the pesky questions that always comes up is, putting aside their psychological overlay that they might have, looking at their physical injury alone, what is the maximum hours per day, days per week that they could do suitable employment? And that's one I get. It's hard to disentangle that psychological overlay from a physical injury, but unfortunately the law says we have to do it. Do I agree with how the law said that? No, I don't. I think it's really hard, but we're unfortunately stuck with it. But the reason we ask this question about hours per day and days per week is that, particularly under work cover and only under work cover, in order for patients to be able to claim wages to retirement age if they have a serious injury, the only way you can do that is to show you cannot earn 60% or more of your previous income in any job you have the skill to do. It doesn't have to be your old job, could be a new job. So flipping it a couple of ways, if they run $1,000 a week and there's another job they could do that got them $600 a week, they can't make a claim for wages to retirement. The law actually says where you're allowed to lose 40% of your wage and you can do nothing about it. So that's why we ask this hours per day, days per week question, because in the background as lawyers, we've got a report about what jobs they could do. We've got hourly rates about what those jobs give. And so we match that up to the hours and see whether they simply beat that mathematical rule of 60-40. I know that's an annoying question that we do ask, but that's the reason why we ask it, because we want to know, are they going to beat this 60-40 rule under work cover? And then, of course, one of the questions we always ask is consequences. And so have regard to a number of things when you're looking at consequences. You know, their sleep, how are they getting sleep? Are they getting enough sleep? And tying that in back to their work capacity. They might have a theoretical work capacity, but practically if they're getting 2 or 3 hours a night of sleep that isn't broken, are they going to be able to go to work every day reliably and consistently and do their job? That's a question for you to determine, but it would be hard. I know if I had to operate off a couple of hours of sleep every night, it would be difficult for me to concentrate the full 8 hours at work. You know, what can they do around the home? What were they doing around the home? You know, what sort of sporting activities were they doing beforehand? You know, what was their social life like, you know, and their enjoyment of life overall? You know, what are they doing now they may or may not have done previously? And then, of course, and absolutely you're the experts in this, is, you know, what treatment are they having and are they getting any benefit out of it? Court cases can't run for injured workers until essentially their treatment is basically stopped. It's at a point where you as surgeons or the treating physio or anybody else has said, listen, there's not much more we can do. We can keep you at this level. So, you know, we might give you an injection in your spine every 1 year, that'll keep you at a level. But we're not going to see any improvement in you. And you're writing your reports to be able to say those sorts of things. But as lawyers, the courts and us won't run a case until we hit this, what we call stability point, where all their treatment's done and they're as good as essentially they are going to be. Because whilst we don't have a crystal ball and we appreciate that, we want to make sure we're doing the right thing by the client and that there's not going to be, you know, some dramatic drop off in their work capacity in the next 6 months. So I'm always more cautious about running a case until we sort of have a really good understanding of what their future holds. And you'll always be asked to give your prognosis, and, you know, prognosis, if you're not certain, you know, your prognosis could be considered guarded as well. So sort of how can we help? And I know I've whipped through the presentation pretty quickly tonight. We're under a pretty strict time limit, but I've tried to do it as quickly as I can. We offer sort of free advice to patients and surgeons. Right at the end on the slide is my mobile number. Feel free to give me a call if you ever want. If you're ever not sure about something, I'm happy to run hypotheticals. I run lots of hypotheticals almost every day off my mobile, so more than happy to do that for you if you're not sure. We act for your patients on no win, no fee, and we pay for report fees up front, and we absorb the cost of fees that WorkCover and TAC don't pay client, you know, us back for. In terms of report writing, that sort of covers it off tonight. It's a quick summary. If you need, I'm happy to make the slides available to you. So if you wanted to go over the slides, please feel free to email myself or let the team know, and we can get them to you. And sort of, I always like to leave the presentation on, well, why refer to a lawyer? And I know there's this apprehension that, don't want to refer to a lawyer too early, they'll just want to do the compensation. In Victoria, there are caps, there are limits on compensation that clients can get. And I've always said to every client, you are better going back to work than you are getting the maximum amount of compensation that you possibly could. And I think by referring them early, we can empower them, they can have that knowledge. And even if it's just for things like getting their treatment paid for, so they can get back to work, they're sorts of things that we actually don't charge for at our firm. So if they wanted treatment, just come to us to try and get their surgery paid for example, we're happy to guide them through that process for free. Question and answer, I'll skip over that. My details are there. So obviously, if you require anything, Yianni Zapparas, who's one of the partners at the firm, email and mobile's there. My email and mobile is there as well. Feel free to call us. We're always around to have a bit of a chat with you as well. But otherwise, that's all from me. Thank you very much for the time.
Thanks very much, Tim. That was fantastic, and thank you for such a succinct summary on the aspects of WorkCover. It is something that we all will end up having to be involved in or write a report on, and I think the advice that both Patrick and I would like to pass on is, if you are in this situation, get the experts to guide you, and rather than just sort of try and navigate on your own, because it can make life quite stressful and frustrating. So keep your questions coming in, please. We will answer them at the end. I'd like to now introduce our second speaker, who is Emma Byrne from Baker and McKenzie Lawyers. And Emma is going to talk about legal contracts and bullying and harassment and aspects of employment law. Thanks, Emma.
Thanks very much, Marilyn. I'll just share my screen and make sure that's all working. Okay, it should be good to go now. So thanks everyone for having a listen. Today I'm going to be talking about a range of different things to do with workplace laws. So hopefully you'll stay engaged. I know it's not, legal stuff is not the most exciting topic, but as you move into private practice, some of these things become relevant and you may not have had to deal with them before. So always good to get background. Just a little bit about me. I'm a senior associate in the employment team at Baker McKenzie. So I do all different range of employment related issues. So bullying and harassment is bread and butter for me. Termination, workplace grievances, employee misconduct, anything and everything to do with employment and safety. So today we're going to talk about engaging employees and contractors and what the difference is there. Discrimination, workplace bullying and harassment. So the first thing you need to do when setting up in private practice is obviously looking at who you're going to engage to work with you and for you, and how you'll engage those people. So there's a key difference here between employees and contractors, which some people sort of don't appreciate in the beginning. Employees get access to a whole raft of minimum legal entitlements which contractors don't. So things like having access to the national minimum wage, paid holidays, personal leave, long service leave, all those sorts of things. And employees are also, they have to follow the employer's lawful and reasonable directions. So you're really at the directions of your employer. You've got to do things the way that they want things to be done generally. And you also have to perform the work personally. So employees can't just sub in someone else. They can't just decide they want to send their mate along to do the job on a particular day instead if they don't feel like it. So comparing employees to someone like your builder, who's a contractor, who you engage to provide services, but they can delegate, so they can send someone else to come in on a particular day rather than doing the work themselves. Employees can't do that. It's really about the personal relationship that the employer has with that particular person when they're an employee. You could also choose to engage people as contractors instead of as employees. So contractors are people who are really conducting their own business. So you engage them to provide services to you as part of them operating their own business. So they're usually paid to achieve end results or for particular projects. So for example, your electrician, your cleaner, Uber Eats delivery driver, these are all contractors that you engage for services. They're not employees. So contractors don't have access to all those sorts of employment entitlements that are sort of nice to have. So no minimum wages, no entitlements such as paid holiday leave and sick leave and those sorts of things. And the idea of that is because they're really running their own business and they can be employed in their own businesses. In some cases, they may be entitled to superannuation and workers' compensation insurance paid for by you. And they also charge GST. Just note that there are penalties for sham contracting. So just because you and the person that you're engaging both actually want that person to be a contractor and not an employee, that doesn't actually mean that they'll be a contractor at law. So a court can come along and say, look, they're actually an employee. I know they look and smell like I know you've called them a contractor, but they really look and smell like an employee. And PS, you owe them all this money that you didn't pay them for the paid holidays and all those sorts of things that they would have had as an employee. And PS, here are some penalties if you deliberately engage them as a contractor just to avoid those employment entitlements. So it's not an easy case of, oh, well, I'll pick contractors because then I don't have to give them paid leave. It really does come down to, for each person, what's more appropriate in the circumstances. So consider the different factors. Is this person, operating their own business? Are they working for lots of other different people and companies? Do they pay for their own equipment? Or are they really at your discretion? Do they use your tools? Do they come in and use your computer? So an example is in private practice, someone like a receptionist is clearly going to be an employee. They're coming in, they're using your equipment. You're probably going to tell them what to do and largely how to do it. So either way, whether you're engaging someone as an employee or a contractor, the important thing is to aim for a signed written contract. And the contracts will be slightly different, obviously, depending on which type you're engaging. Even when engaging employees, there are different kinds of employees, and that has different implications for how things play out during the course of engaging them. So within the category of employees, you have full-time and part-time employees who are essentially permanent, ongoing employees. So these employees are entitled to annual leave, sick leave, long service leave under our minimum employment laws in Australia. They're also entitled to notice of termination and redundancy pay. So all great benefits. On the other hand, you have casual employees. These are not permanent employees. In fact, they're technically engaged separately for each shift that you get them to work. So it's really only appropriate to engage people as casuals if they're doing random hours or if there's no guarantee of ongoing work, beyond a few weeks or months. Because of those temporary nature, casuals aren't entitled to a lot of the things that permanent employees are entitled to. So they don't get paid leave. They're not entitled to notice of termination when you're wrapping up their engagement, and they're not entitled to redundancy pay if you ever had to make them redundant as well. So now just moving to the terms and contracts on which you can engage employees. So underlying everything with employees, there are 10 national employment standards. These come from the Fair Work Act, and these basically apply to all permanent employees in Australia. So it doesn't matter what modern award or contract you might have had in place as well, these are always going to underlie the situation. So things like maximum weekly hours, annual leave, long service leave, as I spoke about. And importantly, with permanent employees and casual employees, in fact, you need to provide them with a Fair Work Information Statement. So that's number 10 there on the screen. So the Fair Work Information Statement, you can access it online from fairwork.gov.au, and you have to provide it to all new employees. And it's also just a really good reference point for remembering what your permanent and casuals employees are entitled to. So the statement sort of sets out, it's almost like a 2-page summary of everything you need to know about employment law in a very, very concise framework. So not only do you have to provide that to your employees, but it's just a good thing to have a look at to get you across what these minimum entitlements are and what the differences are between permanents and casuals, so you know how to treat each of those. There are also these things called modern awards, which are based on industry and occupation. They basically set out a raft of minimum terms in addition to those national employment standards, but only for certain employees in certain industries and jobs. You can't sort of just put these to the side and say, oh, well, I've got a contract, so I don't need to worry about awards, they won't apply. They will always still apply. They just automatically apply to certain jobs and industries. So the ones that are probably most likely to arise in terms of engaging people with you in private practice are probably the Clerk's Award. That's going to cover people like your receptionist, secretaries, and also the Nurses Award, obviously if you're hiring any nurses to assist you in your rooms. You're also probably covered yourself by the Medical Practitioners Award when working in hospitals, unless you're under an enterprise agreement. And many hospitals do have all of their doctors, nurses, other professional staff under enterprise agreements. So with awards, if you think someone's covered, check the award or tell your payroll provider or accountant who's organising your pays for your staff, just so that you know that they're factoring in your obligations to any employees who you think are covered. So you have responsibility for that as the employer, and there are penalties for breach if you don't provide the rates that are set out in the award and all the other requirements. Another type of instrument that hangs around for employees are enterprise agreements. So these are very unlikely to arise for you in private practice, but you may be across them from your own employment. So they're usually negotiated on behalf of a large group of employees by unions, so like the AMA. So for example, many hospitals, as I said, have everyone covered by an enterprise agreement. And they just, they're sort of similar to awards in that they again just apply a bunch of minimum terms on top of the national employment standards, those 10, which are sort of more site specific. So enterprise agreements can contain things that unions, really rally for, getting you extra overtime pay, all those sorts of things. As I said, very unlikely that they will arise in private practice. They're really for larger organisations. So the key thing overlaying all this that you need to be conscious of is employment contracts. So you've got the 10 national employment standards. You've also got modern awards potentially that will apply anyway, but it's always important to have an employment contract for all employees, even if they're covered by an award, and even though you've got those 10 standards. Contrary to what many people think, your contract doesn't have to be a nice little package written down with all of the terms that you want in there. They can be verbal, they can be implied if you're sort of operating on the basis that certain things are terms. So, if you have someone work from X time to X time and you never require them to do anything else, that could be an implied contractual term. So generally we always recommend that you put these in place for employees regardless of what else is around. We also recommend that you get help in drafting them. So aside from your lawyer or perhaps your business advisor, they sometimes have templates. The Fair Work Ombudsman, that's the sort of employment regulator and prosecutor for Australia-wide, but they're also the Ombudsman. They've got a really good basic template. It's called a letter of engagement. So if you Google letter of engagement Fair Work, you'll find it. And it sets out basic clauses around hours and duties, and I think they've even got a basic clause in there around confidential information. all of that will be a great starting point for you. Also remember, you might want to include things around intellectual property if you've got any of that relevant to your business. You may also want to emphasise obligations that employees have once they leave you, so making sure that they keep confidential any information they had access to during the employment, even after they leave you. And that's something that can easily be done just by a written clause. So in terms of engaging employees, there's a few things to keep in mind. As I said, implement contracts always and make sure they get signed. Really important that you have their signature on the dotted line and that you keep a copy of that. When engaging employees, you'll also need to pay for a few things that you may not have had to factor in before when working for someone else. Superannuation, taxes like payroll tax, for example. These things will generally be handled by your payroll provider or accountant, but just good to keep in mind. Also, workers' compensation insurance. And the last thing is just budgeting ahead for your employees' annual and long service leave accruals, and also who will cover people while they're away. So just thinking ahead about those sorts of things, making sure you have the finances set aside and making sure you've got a plan for, you know, if someone wants to take a couple of weeks of holidays at the end of the year, or if they're going on 2 months long service leave after a period of years. I'm now going to talk a little bit about discrimination. This is sort of directly related to bullying and harassment, but I just thought it was worth talking about it as a separate topic. So not all unfair treatment or discrimination is actually against the law. Many people think that you know, discrimination is bad and we can't have it and it's all illegal. But in fact, it's only unlawful if it occurs on certain grounds. So things like race, gender, sexuality, and in certain areas like at work. So there's a mix of state and federal laws covering discrimination, but generally all the laws are aimed at ensuring that workplace rules, policies, practices, and people's behaviours at work are fair and that they don't disadvantage people that belong to particular groups. So at law, the meaning of unlawful discrimination is when someone or a group of people is treated less favourably than another person or group of people because of a prohibited ground. And you also can't take adverse action against an employee because of a prohibited ground. So, for example, dismissing someone because they are pregnant. So on the screen there are all the different grounds on which you cannot discriminate against people at work. There's the obvious ones there like gender and age, disability, but there's also some that you might not expect. So things like someone's union activity or even just their status as a parent or carer. That's a ground on which it is illegal to discriminate against someone in employment. There's a number of ways that discrimination can pop up in the workplace. Recruitment processes, choosing who to hire, who not to hire, terms and conditions of employment, promotion and transfer, training and other employment benefits, and of course, dismissal. So some examples of this in terms of the different grounds and the sorts of things that arise in employment just to look out for. Not hiring someone because they're transgender, for example, overlooking an employee for a promotion because they're pregnant, targeting older employees for redundancy because you think, oh, well, they're old and so they must be looking to retirement, not offering someone an interstate training opportunity because they have children, and also less obvious forms of indirect discrimination. So things like requiring people to be of a certain height. That's obviously not going to arise in your practice, but just to take a basic example, that sort of thing is going to discriminate against people of particular races. So, for example, someone of an Asian race, because on average, they are shorter. Also, just remember in terms of discrimination that this is just a common example we see. Employees on parental leave, they actually have a right under the Fair Work Act in Australia to return to their pre-parental leave position once they come back from parental leave. If that position doesn't exist anymore because it's been made redundant, they have an entitlement to an available position which they're qualified for and that's nearest in status and pay to their previous position. Now moving to talk a little bit about bullying. So I just want to start by talking through a real case example of this, which is Brodie's case from 2010. And this is actually the case that led to the bullying laws that we now have. So as well as the bullying laws, we also have general work health and safety laws, which is how this case was dealt with at the time. But after this case, it was felt that Australia really needed a specific law to target bullying, which has since happened. So in Brodie's case, a waitress at a Melbourne cafe was subjected to bullying by her colleagues over a long period of time, a couple of years I think it was, verbal and physical abuse, but also just unreasonable work demands. And the owner of the cafe was aware, but didn't take any effective action. And Brodie ended up committing suicide as a result of this. So, as I said, at the time, the work health and safety laws were the only thing available. So the employer, director of the company, and 3 employees were all prosecuted, big fines, as you can see on there, including personally against the employees who engaged in this behaviour. So as I said, we now have, as well as the work health and safety laws, specific bullying legislation. And bullying is defined under that Act as where an individual or a group of people repeatedly behaves unreasonably towards a worker, creating a risk to health and safety. So there's a couple of elements there. It's got to be repetitive, it's got to be unreasonable, and it's creating a risk to that person's health and safety. And this actually extends not just to employees, but contractors, trainees, basically anyone who's at the workplace. So this is a real boom area for work health and safety prosecutions, but also workers' comp. We're seeing more and more workers' comp claims for bullying, harassment, and just generally difficult workplaces. It's obviously not ideal to have your workers off on extended periods of stress leave, so and your premiums will go up. So it's just something to keep in mind. There's some examples on the screen there of underlined couple that could be relevant in the health profession. I'm sure you all know what's bullying. What you may not know is what's legally not bullying. So importantly, you can still undertake reasonable management action as long as it's carried out in a reasonable way. So reasonable performance management is not going to be bullying, and also one-off instances of rudeness, for example, not going to be bullying. And what should you do about it as an employer? Well, first thing is to have a written policy, combine it with a policy on harassment and discrimination, and train people on it, reinforce it. Also regularly monitoring behaviour and calling it out and taking action to stop it. If you do see it happening, you have that responsibility as an employer and also as a colleague. And lastly, just talking about harassment. So at law, harassment is unwelcome conduct where a reasonable person would have anticipated that the person harassed would be offended, humiliated or intimidated on the basis of any of those attributes on the screen. So those same attributes that relate to discrimination are also relevant for harassment. There's again some examples on the screen, obvious things like racist remarks, name calling, but also things like criticising employees just because they take sick leave. Sexual harassment is sort of a subset of harassment, and basically it's unwelcome sexual advances, requests for sexual favours, other stuff of that nature. Again, where a reasonable person would have anticipated the possibility that the person harassed would be offended, humiliated or intimidated. So for example, there was a recent case where the court agreed that it was totally fair to terminate a hospital employee because they privately sent a sexually explicit Instagram post to a young graduate nurse who they barely knew. There's some other examples on the screen. They're all going to be very obvious to you. But the important thing to note is that in terms of sexual harassment in the workplace, which is what's regulated under workplace laws, workplace has a very wide definition. So the courts have found that employers and employees can be liable for sexual harassment at work in, for example, accommodation for a conference, at Christmas parties, and even after social events organised by work colleagues, but it's outside work hours and it's at some employee's house. Bars across the road from the office, there was a case on that basis, and the victimised employee was awarded almost $500,000 in damages, and the employer pays because of vicarious liability. So you're responsible for the actions of your staff as well as yourself, and it's the employer who often ends up paying because of that legal doctrine. Things that are not a defence to a harassment claim: I didn't mean it, I was just trying to be funny, they didn't actually tell me that they didn't like it. None of these things will get you out of a harassment claim or your staff. And my favourite one there, oh, but it was at Friday night drinks, it was at the Christmas party, or it was at the pub next door. Again, as I said, not going to help you defend a sexual harassment claim. So there was a lot of stuff in there. The laws in these areas can be a little bit confusing, but it basically boils down to a few key points. Essentially, behave like a reasonable human and you'll probably be okay, and make sure your staff do as well. So just keep in mind that you have legal obligations around bullying, harassment, discrimination, and that it's different when you're at work. So the test for what's okay at the pub with your mates on the weekend is quite different to what the legal test is, what happens at a workplace. Also, just embrace diversity. Don't engage in or tolerate harassment, including among your staff. The customer or the patient is not always right, so you also need to monitor the behaviour of people coming onto your workplace and take steps to protect your staff. That's also part of your legal obligations. Handle complaints properly, and also just fostering a positive culture in your workplace. So some workplaces can develop really toxic bullying and harassment cultures over time. As a business owner in private practice, you've really got the power to set the culture of your own organisation or break the cycle. So try to model good behaviour, treat people the way you want to be treated, and not only will your workplace be better for that, but you'll also have a much easier time meeting your legal obligations and avoiding employment-related claims in these areas. If in doubt, favourite lawyer's thing to say is seek legal advice beforehand. Also, the Fair Work Ombudsman, as I said, the website's on the screen. It's a really good resource. They genuinely want to help employers comply with the law. So it's really easy to find answers to lots of employment-related questions on there. And as I said, the Fair Work Information Statement, downloading that is a great start. Thanks everyone for listening.
Thanks very much, Emma. That was a fabulous presentation and covers so many areas that we commonly come upon as problems in private practice. So you've heard from two excellent speakers tonight, and I'd like to now invite my co-moderator, neurosurgeon Mr. Patrick Lowe, to share some surgeons' perspectives on these medico-legal issues. Patrick, what's your sort of experience in this, and any sort of guiding remarks that you could offer the listeners here today?
Yeah, those two talks were absolutely amazing. I hope the attendees really took a lot out of it, because these are two very important parts of your practice. I'll go to Emma's talk first. If I'd known all this 20 years ago, it made life a lot easier for me. The drafting of the contract I found extremely difficult. I needed to get a lot of help with that, and I really encourage all the attendees to ask for help with that, because if you don't get it right early on, you'll be behind the 8 ball the whole way through. You'll be struggling, catching up. What are these person's rights? What are your employees' rights? Just get the draft, get the details correct, and then you'll save yourself a lot of time into the future trying to get the proper pay, proper allowances, and all those matters. With regard to workplace bullying and harassment, everyone should have gone through the operating with respect module from the College of Surgeons. So you should all be well versed about all this. but it doesn't hurt to ask more questions about your roles, your rights, and also what you should and should not do. With COVID-19, I think the sexual harassment will be gone. Is that right, Emma? Because there's no touching. There's no.
Yeah, it's just that easy.
It's that easy. Just have the virus and you're gone. You're safe. No, it's not that easy. It's quite difficult. As far as Tim's talk and WorkCover and the medical legal side, a lot of my colleagues thought, I'm a surgeon. I don't need to deal with that. At one stage or another during your career, you will come in contact with medical reports and medical legal issues. You might say, I don't do medical legal. I don't do WorkCover. I don't do TAC. Well, your patient that you may have been treating privately may be involved in a car accident or may have a work injury. And because they were your patients, you're going to write reports. So get help. It's actually quite rewarding, quite interesting in that field. I didn't want to do medical legal before, but I found the legality, the different questions that they ask really stimulating to a degree. So with that in mind, everyone will have to do medical legal at some stage. So ask for help and talk to your friendly lawyer because they come in with a lot of advice.
Thanks so much, Patrick. I just want to add 2 small points to what Patrick has already mentioned. The first was what Emma raised, and that is that when you run your own private practice, you do have quite a lot of power to be able to create a nice and also supportive environment for your staff. And I think on that point, it is really important to touch base with your staff, and often it might be just one or 2 people, be it your secretary or your practice manager, and actually find out from them, how the workplace environment is, particularly if they also have other staff from other offices who work nearby. And and I often have found that very helpful just to have an informal, once a month meeting. And that helps to identify any issues like the bullying and harassment. And obviously your staff need to feel confident in you that you will maintain confidentiality when they share that information with you. But it does help to identify problems early before they sort of gather moss, and you can actually, deal with them. And as a business owner, you often have to take the lead in broaching these topics with people who might be, creating a poor environment that your staff are also exposed to. And that's definitely something that I've had to do myself. It's not very comfortable to do, but you've sort of got to do it because your staff are expecting that you're going to be looking after them. So, it is really important to know what your legal standing is. And talking to someone like Emma, if you run into that sort of an issue, will give you some better guidance, I think. The other thing I want to touch on is what Tim said, and that was about WorkCover. Sometimes you'll have patients that are coming to see you that you don't know that the reason that they're coming to see you is, because of a WorkCover claim, etc. It really shouldn't change how you practice your surgery and how you actually treat the patient, but it often does mean that you find out down the track and that you then have, a fair bit of paperwork to complete. I have a registration form which all the patients fill out at my practice, which actually asks them for some information, including whether or not, they do have WorkCover and that sort of thing. And look, obviously it's information that they volunteer, but it is helpful for us to, for the staff particularly, in terms of, number one, billing the patient for the services that you provide, but also then when, the forms come that the patient wants you to fill out for their WorkCover claim continuing, etc., at least you've got a little bit of a warning about that. So just 2 different situations where, what we've talked about today may also be sort of helpful. we do have some questions that have come up for the panel, and I'd like to invite both Patrick and Emma to sort of comment on these. So the first question is basically, I might direct it to Tim, but I might also ask Emma if she could comment from a standpoint of, you know, what she's spoken about today in terms of contracts, etc. And that is, are there courses available for medico-legal report writing, particularly aimed at helping doctors to, you know, get through the process in a speedy fashion? So Tim, I might just ask you to comment first, and then Emma.
Of course. Almost probably it's a more question for you guys than for me of whether there are courses available. I know there are some courses out there about being an expert witness and report writing. So I know there are some courses out there and available to you guys, and I'm not sure whether you guys might run them yourself as well.
The College of Surgeons does run some additional courses that don't specifically cover medico-legal report writing, but there are definitely sources that we could refer you to. And if that is something that, you know, any of the participants today want further information on, please write into us, and Catherine and Virginia can source out some of the sites that we could, you know, direct you to. So that's the thanks for that, Tim. Emma, from your standpoint, any sort of resources that you think the doctors might find helpful in terms of either the legal, you know, understanding the legal obligations, or report writing, particularly, you know, from an MDO type perspective?
I'm not too sure in terms of the medico-legal report writing resources, but what I would add is just in terms of resources on employment law more generally. So for people who are about to embark on the terrifying process of engaging your own staff, certainly the Fair Work Ombudsman website, which is just fairwork.gov.au, is a really incredible resource. It covers all areas of employment law. It's not in legalese speak, so it's really easy to understand. It's got resources, it explains things, it tells you about pay, it tells you about awards, all those sorts of basic entitlements. And as I said, their letter of engagement template, if you just Google that with Fair Work, you'll find it, and it's a really good starting point for an employment law contract.
Okay, great, thank you. Look, the other question is directed to Emma, and it's about medical contract. Are there, is there availability to obtain templates, etc., if, you know, surgeons want to try and do their own contracts? And are there any particular sort of aspects of the awards that need to be actually added to these contracts?
Yeah, it's a great question. So I'm not aware of any templates specifically directed at health professionals, but as I said, the letter of engagement template that you can access through fairwork.gov.au is a very good sort of standard template. There are certainly some things that I would recommend you consider. I think as a surgeon, there are some particular clauses that you should make sure you beef up in your employment contract. And I think there are small parts on this in the template that you may need to add and embellish. And that's as far as confidential information and intellectual property, and also reinforcing that those obligations extend after your employment ends with the particular practice. So just an example of that is, I know recently there was someone very high profile who left Monash IVF, for example, set up their own practice. I'm sure this happens a lot in the industry in different areas of specialisation, but obviously that person is going to be very competitive to the clinic that they've just left. And sometimes if you don't have appropriate clauses in your contract about about the fact that they can't use anything confidential from your practice in their new employment, then you may get into trouble. So just important to have good clauses on confidential information, intellectual property in case you develop anything useful in your own practice. But even just, thinking about things like your own templates, the way that you treat your patients and all those sorts of things, that can all be considered confidential information, and you just may not want, your practice manager or your nurse running off and sharing the way that you do things with their next employer. So those are really important. So far as awards, the thing to remember when doing your employment contract is that if you do have an employee who's covered by an award, or you think they are, and again, there's information on the fairwork.gov.au which will talk you, but if you do have someone covered by an award, you are required that they're covered by an award. So the best place to do that is in the employment contract. So again, just including a clause saying you're a receptionist, you're covered by the Clerk's Award, you're covered at this level. There's generally different in each award, so that they know what their entitlements are as well.
Emma, I've got another question from the attendees. Just read that out. I'm consulting in Central Place for my practice, but they are expecting 40% of all my billings, outpatients and surgical billings. The surgical patients are generated at different practice away from the city and are charging 10% for the billing, with the unspoken expectation that the patients are followed up with them. Is it legal or fair for the central practice to force me to charge 40% billing for the patients that are not generated by them?
It's going to come back to the agreement. I mean, obviously I'd have to know, about the personal situation, so I wouldn't take this as personal advice, but I think it's all going to be down to what you have agreed with that particular practice, what you've agreed with that clinic. So if they've got it in writing somewhere where you've said, yes, I'll give you X component of what I'm billing versus whatever you're going to keep for yourself. It's really, there's no specific law saying that, a salesperson or a doctor or whoever else get to keep however many of their profits. It's all about the arrangement that you have with whoever's engaging you. So it also might be different depending on whether you're engaged as a contractor to that clinic or as an employee. Sometimes if you're a contractor, you have a bit more bargaining power, but it may come down to just what you've agreed with them, whether you're prepared to just take your business elsewhere, or whether you kind of need their support in order to get patients in and develop a business.
Okay, additional information. Okay, all verbal conversations and no written agreement. Does that change things?
Look, for me, when things are verbal, it's going to be hard for people to prove things. So you may be able to open up a dialogue on that basis and push back a little.
Can I just add a comment here? I think it's really important when we're starting out in private practice. A lot of people sometimes get very attracted to group practices because there's already a structure in place and there's, the staff are already organised. You don't have to hire anyone. And I just caution everyone, I think group practices are a fantastic, setup, but they're not for everybody. And I think it is really important when you're offered a contract to join a group practice, if you as a surgeon don't understand the nuances in the contract, that you actually do take it to an employment lawyer and get them to actually decipher it for you, so that you know what you're signing up for, you know what percentage of your earnings, the contract is asking you to do away with, because the last thing you want is to sign something and then be caught up in a situation where you sort of feel like you have done yourself a disservice. So group practices are great. You just got to make sure that everyone's on the same page about what the expectations are, you as well as the practice that you're joining.
Yeah, the other thing I would say, if you're having trouble negotiating around your terms of engagement, whether it's as a contractor or as an employee of a group practice, is tapping into your resources. So talking to your colleagues who may be at other practices already, finding out what their terms are. Often these things are always said to be confidential, but you know, you can always talk to friends, and you can still keep that information confidential, but you can use it at a high level to your advantage in terms of putting that back to someone that's looking at engaging you and saying, well, look, you know, I know people that are on terms X, Y, and Z. Would you be prepared to reconsider?
Thank you. So on that note, I'd like to thank Tim and Emma for taking the time to chat to us today. And thank you, Patrick, for your wonderful insights as well into this topic. For everyone who's been listening and for anyone who missed any segments of this, we will be putting the recording on the college website. Our next webinar is actually tomorrow at 7 p.m. and it's on that important topic of mitigating risk, protecting your most important asset. We would obviously love to hear back from you in terms of feedback about what you thought about today's webinar. And as you know, participation in the webinars does attract one CPD point in category 3 in the maintenance of your skills and knowledge. So, you know, continue to tune in. The topics are relevant and they are really important to helping you to, I think, to navigate, you know, in a better way through the minefield of setting up your own private practice. The other thing that I'd just like to let you know about is that if you'd like any further info in relation to the RACS feedback and complaints process, then you can visit the feedback and complaints page on the RACS website or contact Loretta Drago, and her contact details are actually on the website as well. So in summary, thank you all for joining us today. I hope that you've been enlightened about the legalities of aspects of working in private practice. And thank you to all the behind the scenes work that Virginia and Catherine and the team at RACS have done. Thank you to Patrick and have a great night, everyone.
Thanks, everyone.
Thank you.